For 13 years now, there's been a dispute, a long-running saga, as to whether the drivers for Domino's Pizza are employees or independent contractors. 13 years it's been going on, and now finally it's been decided by the Supreme Court that the drivers, the Domino's Pizza drivers, are actually employees and not independent contractors. So the drivers themselves were involved in contracts of employment or contracts from 2010 and 2011 with Carshan Midlands Limited, trading as Domino's Pizza. The drivers employed or argued that they were employees for tax purposes. Carshan said they were independent contractors. Carshan appealed a 2008 decision of the Revenue Commissioners, the Tax Appeals Commissioner, that delivery drivers should be treated as PAYE workers. So the Revenue Commissioners were quite clear that they should be treated as PAYE workers and employees. The High Court rejected the appeal, so they're still considered to be employees. Then the Court of Appeal, I think it was last year, in a 2-1 majority decision, overturned that decision of the High Court. So the Revenue Commissioners came back then for another nibble, and they appealed it to the Supreme Court. And now in the Supreme Court this week, and today is dated the 20th of October, on today's date in fact, 20th of October 2023, by a unanimous decision, the Supreme Court, 7-judge Supreme Court, has overturned the Court of Appeal decision and has decided that the employees were in fact, or that the drivers, the Domino's Pizza drivers, were in fact employees and not independent contractors, as the Court of Appeal had decided. Basically, there is 5 questions, according to the Supreme Court, to determine whether a contract is one of service, which is an employee, or for services, which is an independent contractor arrangement. And according to well-established case law, according to the Supreme Court, there are 5 questions that must be looked at. 1. Does the contract involve the exchange of wage or other remuneration for the work? So clearly the answer is yes in this case. If so, is the agreement one in which the worker is agreeing to provide their own services and not those of a third party to the employer? And if the answer to that is yes, does the employer exercise sufficient control over the putative employee to render the agreement one that is capable of being an employment agreement? If those 3 requirements are met, then the decision maker must determine whether the terms of the contract between the employer and worker, interpreted in the light of the factual matrix, are consistent with a contract of employment or some other form of contract. And regard must be had to whether the arrangements point to the putative employee working for themselves or for the putative employer. In other words, whether they're self-employed or employees. The judge said in the Supreme Court as well that it should be determined whether there's anything in particular in a particular legislative regime under consideration that requires the court to adjust or supplement any of the foregoing requirements. The bottom line is the Supreme Court has decided that the Tax Appeals Commissioner was entitled to conclude in this case that the drivers were employees of Carshan for the purposes of the Taxes Consolidation Act 1997. And one of the factors there, the evidence disclosed close control by Carshan over the drivers when they work. There were some features of their activities that were consistent with being independent contractors engaged in business on their own account, but the Commissioner was entitled to conclude that the bulk of the evidence pointed to the drivers carrying on Carshan's business rather than their own. The contract was one that envisaged personal service by the drivers, with the facility for substitution on certain conditions, with the substitutes being paid by Carshan and not by the originally rostered driver. So remember, if a person was an independent contractor and if they couldn't do the job and if they got somebody else in to do the job or do the work for them, then if they're an independent contractor, clearly they'd be paying the substituted driver. Whereas in this case, if a driver was unable to perform, then they could get a substitute, all right, but the substitute was paid by Carshan, that is Domino's Pizza. So the judge said that it must be stated that the finding that these drivers were employees did not bind any driver who may wish to contend that they were not an employee. So paradoxically, even though the Supreme Court has decided that they were in fact employees, the court has said that if a Domino's Pizza driver wants to argue that they were actually self-employed for some reason, well then this decision wouldn't necessarily rule that out. The question of costs will be decided by the court if agreement cannot be reached between the parties in 2 weeks. So the parties have 2 weeks to decide who's going to foot the bill, the legal costs, etc., etc. I don't know what the arrangement has been for costs to date, but going to the Supreme Court, after the Court of Appeal, after the High Court, clearly there has been significant legal costs, but I'm not sure what orders may have been made to date. But the question of costs will be decided by court if, as I say, the parties cannot reach agreement. And one other thing that needs to be looked at, the question of whether drivers have continuous service for the purpose of other legislation, in particular employment rights legislation, cannot be decided here. The Supreme Court decided. So that's the 13-year long-running saga of Domino's Pizza drivers. Are they employees? Are they self-employed independent contractors? The Supreme Court has now decided that they are in fact employees. Hope you find this video useful, and you might hit the old thumbs up button down below and subscribe to my channel. And if you're listening to this on iTunes or on Spotify to my podcast, the Irish Law and Small Business Podcast, you can sign up or submit, or not submit, sign up for to receive updates about my latest updates or latest podcast episodes and so on. And you can subscribe either on iTunes or on Spotify, and you can leave a review if you don't mind. It'd be great if you did. Thanks a lot.